I'm Pat Doris. Welcome to The Story. Tonight we have a lot of great stories for you, including an update on a Clackamas mom who wanted to use CBD oil to treat her daughter's cancer. How'd that work out? We'll take a look. Plus, the latest on the effort to overturn federal court rulings that keep the West Coast cities from enforcing most homeless camping bans. But first, the bill to recriminalize drugs just took a big step forward in Salem, and that is our big story tonight. We're talking about House Bill 4002. The bill passed out of the Joint Committee crafting it about 40 minutes ago and is now headed to both the House and the Senate for votes. Just to make sure that we're all up to speed on this, the bill would recriminalize drugs in Oregon, ending the 3-year experiment that was Measure 110. It would make it illegal to use drugs in public and will have criminal penalties for possession of even user amounts of drugs and enhanced penalties for drug dealers. But the bill also has several off-ramps to prioritize treatment for drug users, but there is also the potential for jail time if they do not accept or complete treatment. The work session tonight began with many Republican lawmakers talking about wanting the bill to go even further than it does now. But despite those concerns, they are happy that a compromise came this far, and many do plan to support the bill. The committee co-chair, Jason Kropp, a former prosecutor and a Democrat from Bend, said this is an entirely new approach.
We heard from law enforcement repeatedly that they wanted the tools to be able to intervene and confiscate drugs in our community, but they did not want to take people to jail. We heard that uniformly from law enforcement. We are providing a framework to make that a reality. We are providing funding so that local communities can set up programs for people who are found in possession of drugs, don't even need to go to court, that they can be immediately connected into behavioral health services in their community and not be prosecuted. We have commitments from 23 counties to start that different approach up. That is a dramatic change in the way that we have conducted business in the criminal justice world in this state.
I know it's not the most exciting video, but this was a talk that happened right before the vote, and it's a moment in history, Oregon history. And then something unique happened as Representative Kropp started to talk about the many people who had testified and the many who are in recovery who shared their stories along the way. And he got emotional, showing this experience has moved him deeply.
I feel some level of hope, in part because of the stories that we heard throughout this whole process, right? People who have lost family members and showed up to testify here and are working in their communities to make sure that doesn't happen to other family members. People who had their own struggles with addiction. We had I'm good, thank you. We had somebody celebrate their 20-year anniversary with us last night. That's incredible, right? She showed up here last night. She's helping other people in her community. I'm going to support her, right? I'm going to find things that we can do on the state level to help her, help other people.
Yeah, you can tell he cares a lot. But it's also worth noting that the bill does not have the unanimous support, not even in this committee. It passed to the House and Senate on a 10-2 vote. One of those no votes came from a Democrat, Floyd Przansky, from the Springfield and Eugene area. He thinks the bill is being rushed and will only make some current problems even worse.
What I see right now with the bill that's before us, 4002, with the -33s, we're basically following the similar path of what happened with Measure 110. We're accelerating everything so quickly to try to get something out without thinking and even learning from the past 3 years. Since Measure 110 passed by the voters, it went into effect the following in November of 2020, and 2021 had an effective date. We did not have all of the programs we needed to be in place, such as the treatment. And at this point, we're going to see a same result, or a similar result, I should say, as to the lack of treatment services. And in this case, one of the bigger failures I see that will happen much sooner than that is going to be the inability for the courts to work through this process. With the lack of defense attorneys, as we've heard through the testimony, over 2,800 people currently in this state are eligible for public defense, do not have it. Of that, 170 plus are sitting in jail right now without an attorney. And we're getting ready to put in, from what the testimony showed, somewhere between 2,000 to 4,000 cases on top of the problem we have not addressed. I cannot see how we are moving forward when we don't have the infrastructure in place.
Now, you flooded our email and voicemail inboxes last night when we talked about this bill. We'd love to hear your thoughts now as the bill is moving ahead. We'll feature some of your comments tomorrow night, and we'll be watching House Bill 4002 as it moves through both the House and the Senate. We're going to bring you updates every step of the way. Now let's talk about homeless policy across the West. The reason you see so many people camping along our freeways and in our neighborhoods or cities, well, it's because local governments are forbidden from enforcing camping bans if they don't have enough shelter space available for homeless people. The rule tying the hands of local government comes from a federal Ninth Circuit Court of Appeals decision called Martin versus Boise. It involved a case from Boise, Idaho, but see this map? The federal Ninth Circuit covers a lot of territory, from Alaska down to Nevada and Arizona and Hawaii. And that one case impacted everyone there in the shaded states. Millions, tens of millions of people, and every local government in every one of those states. In that case, the Ninth Circuit said it was cruel and unusual punishment to ban homeless camping for people who are homeless against their will. Now, lawyers trying to reverse that have argued the Ninth Circuit simply got it wrong, that cruel and unusual refers to gruesome things like cutting someone's body into 4 parts, or that's known as quartering, or maybe cutting off their ears or other nasty punishment like that. The sort of stuff done under the rule of King James II in England in the 1680s. Seriously, that's what they say it's talking about. The lawyers say that term, cruel and unusual punishment, actually comes as a reaction to some of the king's punishments. The founders of the Constitution put those words in the 8th Amendment, and it's prohibited. So, if taking action against homeless folks is cruel and unusual punishment, then of course you cannot do that. Which is why you see homeless folks camping everywhere. Now, in 2019, the city of Boise asked the U.S. Supreme Court to overrule that lower Ninth Circuit Court, but the Supreme said no. So it still stands today. But you may have noticed this group, a little different than it was 5 years ago. This is the Supreme Court, and it's now more conservative. And now the Supremes have agreed to take up not Boise, but a different case with very similar facts, and it's from Grants Pass, Oregon. If the High Court reverses the lower court in the Grants Pass case, it would effectively be throwing out that Boise ruling as well. And that would open the door to significant changes in the West Coast and in communities throughout these states to deal with homeless campers. Those who represent the homeless, well, they don't want it changed, and they argue that it is cruel and unusual to punish folks for being homeless against their will. So that's why all of this is important. Now, the latest development is the filing of this brief for the petitioner. It's fancy legal work that says basically it comes from lawyers who represent the city of Grants Pass. And I'm telling you about it because it basically lays out the legal argument the city is making in the case and giving us all a sneak peek on how they're going to argue this thing. The filing lays out the facts of the case. First, the city of Grants Pass has about 38,000 people, and it's in Southern Oregon. When the case was filed, it had 602 homeless people, and all of them became part of a class action lawsuit against the city. The lower court found that none of the shelter spaces in Grants Pass qualified as shelters under the Martin versus Boise case. That's because 138 beds available at the Union Gospel Mission had substantial religious requirements, so they wouldn't count that. It also did not count nearby campgrounds on federal land because, well, it was outside the city borders, so that doesn't count. It also did not count a warming shelter because it was not open year-round, and it did not count a sobering center because it lacked beds. So the court ruled that without adequate shelter for those 602 homeless campers, you can't punish them for camping in the city limits. What was the punishment that Grants Pass was handing out? Well, the city passed 3 ordinances. One prohibited sleeping on public sidewalks, streets, or alleyways. A second prohibits camping on any sidewalk, street, alley, park bench, or other publicly owned property. And a third prohibited camping in city parks. Now, people who violated those rules could get a $295 fine, which could be lowered if someone pleaded out, or could also go up if you were a repeat offender. At the top end, folks could be hit with a $1,250 fine and 30 days in jail. In its filing, the lawyers say the city of Grants Pass issued fewer than 100 of those fines each year from 2013 to 2018. All right, so that's where things stand now. How will lawyers who want to overturn the case argue? Well, it's simple. They're arguing the 8th Amendment prohibited cruel and unusual punishment, prohibits certain types of punishment, not any punishment. The lawyers write, the amendment states that excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. Nothing in that language, they argue, immunizes certain conduct from all forms of punishment. So are you following me on this? They're saying that the 8th Amendment is focused on the punishment, not the crime. And that when it comes to punishment, it only outlaws, those nasty types of punishment. They write, the framers shared their English forebears' concerns about barbarous punishments, such as quartering, public dissection, and burning alive. Good heavens. And they point out the Supreme Court in the past has banned death by firing squad and hard labor in chains. But they argue neither the civil fines imposed by the petitioner in Grants Pass for violating ordinances regulating camping on public property, nor the short jail terms for several violators are cruel or unusual. And then, because lawyers love to cite history when it helps their case, they point to a case way back in 1867 when the U.S. Supreme Court rejected an 8th Amendment challenge to a fine and 3 months in jail. The court back then said the fine and the jail term were not cruel or unusual. And the modern day lawyers wrap things up by saying fines and jail time, that's a punishment that is universal, not unusual, and in the criminal codes of every state and every part of the federal government. The U.S. Supreme Court is scheduled to hear these arguments on the case on April 22nd. Their final decision will likely come, months later, but we'll be watching. And in the meantime, we want to know, what do you think about the case? Do you think passing laws against homeless camping is a way to help solve the homeless issue? Or do you think it's a dead-end road that won't make much difference anyway? Email us, will you? Let us know. Our address is thestory@kgw.com, or you could call and leave a voicemail. The number is 503-226-5090. Coming up next now on The Story, many will remember the story of a Clackamas County mom who tried to treat her daughter's cancer with CBD oil. Well, that mom was sentenced today in court for a case that made national headlines regarding parents' rights to control medical care. We'll have the details when The Story returns. Here's a super interesting story now about the rights of a mother to control the medical treatment of her sick daughter. A Clackamas woman is going to jail for refusing to follow a doctor's orders involving her daughter's cancer. Kyla Boshi has our story.
The Oregon mother who treated her daughter's liver cancer with CBD oil is headed to prison. A judge sentenced Christina Dixon to 90 days behind bars. In November, a jury found the Clackamas County woman guilty of custodial interference and criminal mistreatment for refusing doctor's orders.
I just wanted to give her a chance to live.
The case, highlighted in a KGW investigation, sparked debate over a parent's right to control medical care. In 2020, Dixon told KGW she didn't believe chemotherapy was helping her then 13-year-old daughter, Kylie. Instead, the Wilsonville mother used alternative treatments, including vitamins, herbs, and CBD oil to treat Kylie's cancer at home.
Were you neglecting to take care of her?
Absolutely not. I was doing the exact opposite. I'm literally getting punished for saving my daughter's life, and I can't find the freaking crime in that part of it whatsoever. I just can't.
Doctors wanted to remove the cancerous tumor. Instead, prosecutors claim Dixon ignored a state order to bring her daughter in for medical treatment and fled to Las Vegas, where the FBI tracked the pair down. Kylie was taken into state protective custody and in 2020 underwent surgery.
She had the surgery and she's cancer-free now because of it.
Kylie's father, Jim Dixon, feels there should have been a tougher sentence for his ex-wife.
I was a little saddened to see that how easy she got off on all this considering all the damage she's done.
Prosecutors claim the case proves parents have an obligation to ensure children receive life-saving medical care.
Kyle joins me now. Super interesting story. And the daughter's doing okay with the cancer. What's her relationship with mom?
Yeah, it sounds like she's no longer in state custody. She turns 18 in just a few months. Also worth noting, she testified on behalf of her mother at trial in November and has posted messages of support on her mom's Facebook page.
And why did the mom get such a light sentence?
Right, prosecutors had asked for 19 months. In the end, she got 90 days. The judge addressed this. He said that Dixon doesn't have any criminal history. He also said this is not a repeatable offense. His words, paraphrasing, essentially, a car thief, for instance, you worry about them getting out and stealing more cars. In this situation, the circumstances were so unique, the judge said, it's unlikely it will happen again.
And it'd be maybe different if the daughter was 5 years old as opposed to almost 18.
Sure.
Yeah. All right. Thanks, Kyle. Super interesting story. Coming up next now on the story, a profession we don't often hear much about, stripping. The state of Washington is an outlier when it comes to those workers, and now there's a big push for a stripper's Bill of Rights in Olympia. Dancers go on the record next on the story. Tonight, we're kicking off a two-part series focused on a legal profession in the state of Washington and a fight for basic protection in the workplace. Strippers Are Workers is an organization of 300 women fighting to pass a so-called Stripper Bill of Rights. Washington is the only state in the country that does not allow alcohol to be sold in strip clubs. That means those businesses depend solely on dancers for their income. Tonight, a professor, an activist, a single mom, and a campaign manager for local women go on the record with our colleague Joyce Taylor to peel back the stigma of a profession that they love.
The role the strip club plays in the community is vital. Sex work has always played that role in the community. It taught me so much about myself and how to move through the world and who I wanted to be and what type of boundaries I wanted to store. It made me who I am, and I'm so proud of it.
When it comes to public perception, a show of hands if you think people have a lack of understanding about what you do.
Absolutely. Yeah.
Pretty much everyone, right?
Yeah. I moved to Seattle with the intention of going to law school after I had finished my bachelor's degree, and that's when COVID hit.
I come from a background where it's very difficult to get traditional employment. I'm autistic, so I wasn't fitting into traditional workplaces.
As a teenager, I came from a pretty complicated living and home situation in life, and I struggled with mental illness and other things, so I was in and out of the system.
I started dancing at 18. I was a full-time student at the University of Washington at the time. It was in 2007. Everyone in my family was unable to earn an income, and so my choices were drop out of school or find a job that would allow me to stay in school and support, at that time, 3 adults and my younger sister. I now am a professor at the University of Washington. I worked in tech for about 10 years at Google and Microsoft and things like that. And honestly, dancing's still my favorite job.
I was homeschooled, never got a diploma, so I pretty much have no formal education. I had a kid and a very difficult pregnancy, and after that I knew that I couldn't go back to the low wage jobs and support the 2 of us. So I got on a Greyhound bus, walked into a club, and got hired right off the bat. And that first night was some of the most fun I've ever had. I came away at the end of the night, looked at the money in my hands, and was like, I should have done this a long time ago.
I was really scared that I wouldn't be able to hold on to a consistent, normal job and schedule. And so stripping just seemed like the right way for me to make enough money to pay rent, to go back to school to get my diploma and college degree, and to manage the ups and downs of needing to take time off for myself.
Some of the things that I was specifically looking for in this industry was a job where I could be physically active and focus on my health. I also wanted a job where it could be really flexible about when I work and what my work start times were. I have multiple different chronic illness and just things like chronic migraines.
Do you think that the public's perception of what you do is an obstacle to you being safe in the workplace?
Oh
yeah. I think that is the core of what we are facing, is we are dealing with regulations that are based on stigma that are now further harming us in our workplaces.
People feel we deserve what happens to us, that we are putting ourselves inherently at risk.
Dancing is not inherently dangerous, and also I reject the idea that our customer base is just more violent or dangerous than anyone else.
Let me ask you this question. What do you say to some of our viewers who don't think dancing should even be legal?
No matter what any of the viewers think, no matter what people think, there is a fact that certain women just can't get other jobs. That this is a last resort, and then the resort after that is working on the street.
Are you one of those women?
Definitely, and it works, and it's fun, and I don't have to stand out on Aurora in the freezing cold weather.
This is the safe place. We are professionals. We as humans, we need connection. We need intimacy. And the role that we play, and a lot of times, is really lovely. I have such deep, lovely relationships with some of my customers who frankly could only have that interaction because of the dynamic of the strip club.
I've been organizing the stripper industry here in Washington for many, many years. And dancers are genuinely some of the most skilled, intelligent, and like beautifully empathetic and caring people I've ever met in my whole life. We all deserve to be safe and to be supported, doing something that we're consenting to.
Joyce tells us that the organization Strippers Are Workers is pushing for better workplace protections, including added security and harassment prevention training. We'll hear more about those particular issues tomorrow on part 2 of her series. Well, that's the end of our show. Thanks so much for watching. And remember, the story, our collective story, that never ends. The good stuff is coming your way next, and I'll see you right back here tomorrow night at 6:30.